What is attornment, in commercial real estate leases? Attornment is a venerable legal concept, rooted in common law, which establishes a contractual relationship, specifically, a landlord-tenant relationship, between a new owner of leased property and the existing tenant. In the context of a commercial lease, attornment formalizes the tenant's acknowledgment and acceptance of the new owner as their landlord. Historically, this concept required the tenant's express consent for the transfer of the lease to a new owner to be legally effective. Today, while the requirement of formal consent has largely been replaced by specific statutory provisions and lease clauses, the fundamental principle remains: it confirms that the tenant will pay rent and perform other lease obligations to the successor in interest, and that the successor will honor the original lease terms. The contemporary relevance of attornment is almost universally found within what is known as a subordination, non-disturbance, and attornment agreement. This three-part agreement is primarily negotiated during the financing of commercial property or as part of a lease negotiation where the property is already subject to a mortgage or deed of trust. The attornment provision within the subordination, non-disturbance, and attornment agreement obligates the tenant to recognize the lender, or the purchaser at a foreclosure sale, as the new landlord if the original landlord defaults on their loan and the lender takes possession. This clause is a crucial protection for the lender, ensuring that the valuable rental income stream will continue uninterrupted and that the leases will not be unilaterally terminated by the tenant following a transfer of ownership. For the commercial tenant, the attornment provision is a reciprocal requirement tied to the non-disturbance clause of the subordination, non-disturbance, and attornment agreement. In essence, the tenant agrees to attorn to the new owner only if the new owner, the lender or buyer, agrees to the non-disturbance provision, which states that the tenant's right to undisturbed possession of the premises under the lease will be protected and will continue despite the foreclosure. Without insubordination, non-disturbance, and attornment agreement, a lender might argue that their pre-existing mortgage is superior to a later signed lease, subordination, potentially wiping out the lease in foreclosure. The subordination, non-disturbance, and attornment agreement, via the attornment clause, creates a quid pro quo where the tenant's assurance to pay is exchanged for the new landlord's assurance of continued occupancy under the original lease terms. In summary, attornment in modern commercial leasing is a critical mechanism for risk allocation and stability during ownership transitions. It transforms a potentially disruptive event, like a foreclosure, into a seamless transition of the landlord-tenant relationship, safeguarding the financial interests of the lender, who relies on the tenancy for value, and protecting the occupancy rights of the tenant, who relies on the lease for business continuity. The legal operation of attornment ensures that the lease effectively runs with the land, binding successors and preserving the contractual framework that governs the commercial space. To learn more about our commercial leasing legal practice, visit our website, or contact our law firm to schedule a confidential consultation. Thank you.